It's always a delight to have you join us here on ITV for Law and You. We're live in Benin City, Nigeria. I am Wuyi Agmofwegwe. Welcome to the program. Two issues we want to quickly look at for the next 25 minutes on the program this week. The first is the impact of the coronavirus on the judiciary in this country. We do understand, for example, that the courts are not sitting, at least in the sense of what we traditionally would call court sittings right now. What are the ramifications for litigants? What are the alternatives already on the ground that litigants can explore by way of seeking redress? And the second issue we also want to look at is the small claims courts that have been established in Edo State. The governor had categorically said that these courts will help address many of the issues that small business owners grapple with. He also talked about how that ease of doing business will become much easier as far as these small claims courts are concerned. But how do we make sense of all of these efforts being put in place to ensure that small and medium-scale business operators have faster and more effective access to the judicial system or to justice? To help me make sense of all of these issues, I'm joined by Barrister David Maduko, apparently a legal practitioner, to beat these two issues into context for us. It's always a delight to have you on the program.
It's nice to be here, Wuyi.
Okay, let's begin with the first one, the coronavirus. We understand that COVID is hitting hard on every sector, every industry as we know it. But let's talk about the judicial sector, judiciary sector, for example. Courts are not sitting in Nigeria. Yeah. There are pending cases across all the courts. What is that saying to us right now as a country?
Well, yes, that's precisely the situation, unfortunately. The message is sent out, clear, loud messages. We have to get into other means for our methods of adjudication, methods of dispute resolution and dispute settlement. The Chief Justice of the Federation gave a directive sometime in March that the courts, apart from very urgent matters, matters that are time-bound, and matters of such nature, exigencies, all other matters were not to be heard, courts were to be shut down. And following that directive, most of the chief judges of different states also issued similar directives that the court should be shut down. Here in Edo State, the chief judge, the honorable chief judge, also issued a directive shutting down the courts. Though at some point in time you were having skeletal services in the registry and all that, but as at now, the courts have been shut down. Like I said, the clear message sent to us is that the option available is the E option.
Okay. Is that really effective?
That is another question to be answered. Before now, the courts in Edo State had introduced the e-filing system.
Right.
Where when you come to file your cases, you should accompany your processes with a CD plate, where everything you are filing should be embedded in that system.
Like a digital copy?
Yeah, the digital copy. But how effective that is another issue. Yeah. Because I'm aware it was not strictly and fully complied with. You know, I think this this whole pandemic is now a pointer to the fact that we should start looking more to what the digital world can offer us. China, who has been said to where the pandemic originated from, in their judicial system, they have been able to, you know, take steps to do their filing and other court processes electronically. The judges hear cases and judgments are delivered online. They have developed a special application for their judiciary, which they are using effectively as of today. In Africa, Kenya is a forerunner in this regard. Yeah, they have also been, you know, doing their processes, their filings, and all other processes vis-a-vis to do with court proceedings through the e-platform, and it has been working for them. And I think it's something that Nigeria should emulate at this point in time, and we should also try and sustain as time goes on, because by the grace of God we pray that this pandemic goes. we should move along the line that the world is moving into. We should not be left behind with this our analog way of we have this human interaction, so much human interaction in our judiciary, in our court spaces, in our court halls. I think we should try and de-emphasize on that and go the e-way.
So which means as we speak right now, more than ever before, automation of our court system,
yes,
it should be a priority number one.
It must be.
But what are the obstacles along that line, really, from what you can see?
Well, the obstacles are, one, like I always say in most forums, there's no sincerity of purpose on the part of the government, and the issue of financial autonomy of the judiciary must be looked at sincerely. What is due to the judiciary from the Constitution must be given as it was prescribed. The judiciary should be well funded. If they are well funded, most of these things should have been something that would have been operational by now. Yes, we take our state for example. I think we need to also give a lot of kudos to our governor. He has tried a lot vis-a-vis in the aspect of the judiciary, the buildings are set up and all that, but there is still a lot to be done. The coronavirus pandemic has opened our eyes to see that we must move as a matter of necessity and as a matter of following world best practices. We must move along the line of the e-tech. We must move into e-law, and we can be doing filing, we can even be doing adjudication of cases on the e-platforms. There are so many other applications that can support that. We talk of Skype, we talk of Zoom, we talk of so many, even our WhatsApp and Facebook. There are applications that can be built, along similar lines that will help our justice sector. So it's about time we really looked at that. This has opened our eyes. Lagos has done quite well in this regard. They were the forerunners of the e-filing and all that. And I think in the aspect of their, what do you call it now, probate. They are probate. They have been able to develop an application in that regard.
Just to speed things up.
Yeah, just to speed things up in that regard. So it's something we should emulate. It's something we should encourage. And I think looking into the e-world, e-tech for judicial revolution in Nigeria, there's no better time than now.
I read articles and some exclusive interviews from newspapers granted by some very respected senior lawyers in this country.
Yes.
Some of them share the sentiment that, look, we could have done better than this. In other words, we could have avoided a situation where the courts are shut down amidst the COVID-19 pandemic. What are your thoughts along that line?
Yes, we could. We could have avoided it, like I said, if we had, gone ahead to encourage the e-technology
before now.
In law before now. Yes. We do have some lawyers, we even have some judges that have gone on training seminars and all that on this same topic. But it has not been of a wide application.
Because the environment is not friendly enough.
The environment is not friendly, and the funding is not really adequate for it. So there's a lot of lessons to be learned from this. Like I said backstage, I hope we will come out of this with a lot of lessons to take home. I hope our leaders will come out of this. It's not, when you talk about judiciary, well, we are here to talk about judiciary, but in all other aspects, politically, economically, we hope there's something that we should pick out from this pandemic, and that's the fact that we should move ahead of how we are moving now. We should move with the way the world is moving.
More speed, right?
More speed, because we will be left behind if we continue doing things in our analog manner. We don't go digital, we don't go e-tech. It will be a very sad story for us.
Just before we take a break and talk about something else, let me ask you, you're a practicing lawyer, obviously. How is this affecting lawyers? Streams of income and so on and so forth.
Terrible.
Because briefs are probably not coming forth.
Briefs are not coming. Lawyers are at home. I grieve most especially for my colleagues, especially junior ones who rely on what we call appearance fees. Those are the ones that you go to court and you get paid for the day.
Okay.
Some don't get adequate payment. Some don't even get reasonable payment. I can't even state the amount here. So they depend on that appearance fee. And with this lockdown, it's been very terrible, very, very terrible. my heart reaches out to them. We as a body of lawyers, the NBA Benin, we call ourselves the Lion Bar. We have tried to put some palliatives together, you know, to reach out to especially the young and vulnerable lawyers amongst us.
Right.
But that may not be adequate. So the justice sector, administration of justice delivery system, which is also enabled by lawyers. I think when we talk of palliatives, the government should also put an eye towards that, because
for lawyers.
Yes, because there are a lot of lawyers, young lawyers most especially, who are not having things going smoothly right now. It's quite tough for a lot of lawyers and a lot of lawyers' families, and that is the truth.
Let's look at all of these pandemic and the challenges it presents to us, especially for people in your field of practice. It's almost not possible to want to talk about this and not wonder what you're telling your clients at this point. I mean, those whose cases are somewhere in the middle, trapped on account of this COVID-19 crisis. What exactly are you telling them at this point, for example?
Well, even on that topic, there's been some webinars and seminars on that recently. It's called the incidence of force majeure. It's something nobody planned for.
Right.
An external force that, you know, came about that, you know, it frustrated a lot of things. It's not what we can quite readily compensate for. It's not what you planned for. So, yeah, there are a lot of contract deals, time-bound events, obligatory, agreements that this thing has affected. And of course, it becomes an issue immediately thereafter. There are processes, legal processes too, or legally related processes. Like, for example, mediation. The process of mediation could come in by the grace of God after this is over. For many of these kind of situations, you could mediate on it, and, you know, both sides could meet over a table and say, well, nobody planned for this, but in the light of this, this is this is what we offer. The other one come and say, okay, well, okay, based on this, you know, we reach a sort of compromise.
Perhaps this is the best time to explore the ADRO mechanism, isn't it?
Mediation is a form of ADRO.
Apparently.
Mediation, you know, arbitration and conciliation.
Obviously.
They are very, very formidable forms of ADRO.
Okay, basically, let's turn to a different issue. Everyone, we want to look at the small claims courts that have been established in Edo State. What exactly are these courts? I'm very sure many members of the public, particularly those who are watching right now, are not familiar with this kind of discussion. We'll take a quick break. We're back shortly to help you make sense of it all. Stay with us. Thank you for staying with us on Law and You here on Independent Television. I am very sure when the governor, for example, kept hammering on the importance of these small claims courts, some persons would have been maybe somewhere in their heads having several thoughts, chasing themselves as to what exactly the governor was talking about. And then when the Honorable Chief Justice of the state also came to make mention of the same issue, then lay emphasis on it. Help us make sense of this whole thing.
All right. I think I could start from looking at the judicial process in Nigeria itself. Now, given the expensive and complicated nature of judicial process, you would agree with me that probably only the fairly rich and wealthy citizens of this country can enjoy any meaningful access to courts and justice. And that is the truth. I'll call to mind the late Akinola Aguda, who stated in his article called The Crisis of Justice in Nigeria, where he said that the ones that are able to achieve justice in Nigeria from the judicial process depend on how much money you can spend. We give you the quality of justice that you desire. It may seem, you may seem to want to disagree at the beginning, but if you look at it critically, you will find out the man spoke the truth.
Is that peculiar to Nigeria?
Well, at this point, I'll say yes, because judicial systems develop and evolve.
Okay.
some have developed to the stage that, yes, the ordinary citizen in the street can claim, that they have access to it. But in Nigeria, we are still a far cry. Now, coming to the small claims court, I had to lay that foundation to let you know that it's not everybody, practically, I'm speaking practically now, that has access to quality justice.
Right.
Now, what about the downtrodden of the earth? What about the artisans? What about the poor citizens? This class of courts, called small claims court, were created for this set of persons who have little disputes, little disagreements, so that they won't go through the whole hog, of the, kind of slow and cloggy wheel of justice. They can have speedy and accessible justice at that level, and that is why an amount was pegged in relation to that court, 5 million. Anything short of 5 million, over and above 5 million, you can go to the small claims court. Okay. But below 5 million, and it is a simple disagreement, simple dispute, that you don't need to waste your time on the regular court.
No criminal issues.
No, not criminal issues. You go to the small claims court to get these things, resolved. The small claims court itself has a forbearance to history in relation to the English pie court.
Okay.
In the medieval English times, where you also had those kind of people like artisans and all those other people who went to such court, to seek justice from there. So that's, they call them the English pie powder courts. So it has the history from there, draws its history from there. So now, in a place like Benin, we know our governor is seriously interested in commerce, trading, and encouraging medium and small scale industries.
Right.
And in encouraging such economic motive and moves, you have to make allowance for courts that can easily arbitrate and settle issues that arise from this kind of business deals. So the small claims court came in handy at this point in time in the evolution of the state, that when you have this little dispute here and there, you do not have to go to the regular court. So for the not so rich people, the artisans, and the lowly, they can go to this small claims court. You do not necessarily have to engage a lawyer.
Okay.
That is one other practical thing about the court. You go there.
So is it a walk-in process?
Yes, you can walk in. There are certain forms you will fill, give certain details. Your name, nature of your claim, the kind of witnesses you choose to want to rely upon during the court, and all that. And you don't also necessarily have to know the name of the defendant. You can, just describe it. This whole process has been made simple, so that when you go there, the defendant are served with your claim. They also have, I think, about 7 days to put in appearance and all that. You come within a certain specific time. Your case is heard.
How long are we looking at, give or take? 1 month, 3 months?
Yes, it depends. It could be within a month.
I'm looking at members of the public, because let's not run away from the fact that apparently our economy is not very structured. We operate an informal economy, both on the states and federal levels. Yes. That said, how does this play out practically, to use your word, for the average woman selling small items at a Dike market right now, or the artisan somewhere on the Ruby, around the Yarrow or something?
Yes, another problem we might have may be that of publicity and awareness. Yes, the small, the market woman selling at tomatoes or other items at a Dike market may not be aware that such a court exists. So I think the arm of government that is responsible for creating such awareness would be the National Retention Agency. They have a duty to go around to enlighten the citizens that look, such and such a court exists. To ventilate your grievances, your ideas of any wrongdoing against you, your person. You can go to such a court and you get justice expeditiously. So such an organization is burdened sadly with that responsibility to do so,
create awareness
create awareness about the existence of this kind of court. You know, and in a forum like this, we are also talking to the public through this medium to let them know that such and such a court exists in Edo State. And I think it's about the third state in Nigeria.
After Lagos.
After Lagos and Kano, if I'm not mistaken. You know, so they should take advantage of it. There will be no need for our fathers, our mothers, our brothers and sisters,
so
to
be running to regular courts.
To be running to regular courts.
Just one more question before we're done with this whole discussion. The issue of sustenance.
Yes.
You know, this initial excitement that we get when things like this are rolled out.
Yes.
How do we make it a long-term initiative in such a way that it is as effective in 20 years' time, in 50 years' time, as it is today?
Today.
Yes.
Well, it's a matter of evolvement. Things evolve.
Okay.
And you become better as time goes on. I strongly believe the Honorable Chief Justice of Edo State, my Lord Justice Esther Menagawa Edighi, has established this court, and I strongly believe that as time goes on, that the practices and procedures
will also evolve.
Will also evolve and will get perfect as the time rolls on. It's just starting. And we will have the benefit of advantage of being the third state in the country.
That sounds like pioneer status.
Yeah, that's pioneer status. So we have the advantage, of experience on our side. So as time goes on, we will clearly know our lacunas, we will know our shortcomings, and as time goes on, the thing will take itself to perfection. For now, it's just for the citizens, those that fall within that category, to take advantage of it and take most of their, disputes and other forms of grievances to that court, to make it active, to give it the live wire it needs, so that others will get to know of it and it will become very, very functional.
Okay, I think that says it all. Two things. The first is we need to be aware, first of all, that a setting like this kind of initiative is in place. And second is to make efforts, practical efforts, to ensure we also take advantage of it, because this course, we understand, of course, are for members of the public, particularly those within the informal economy or the informal sector, as we know it. And one thing that really stuck out for me in the course of the trajectory that Barrister Maduko established was the fact that he said you don't necessarily need a lawyer to access this kind of service. So in the days and weeks and months and years ahead, we are going to continue to advance this conversation so that everyone will get to know that such a system is available within the judicial system in the states. That's our program for this week. I would love to thank especially Barrister David Maduko for coming on the program and spending part of your lunchtime with us.
Thank you.
Okay. Yeah. We'll see you next week, Monday, 3:30 p.m. West African time. I am Agmo Fuegbe. You can follow me on Twitter at Sage Dazzle. Enjoy the rest of your Monday.